Good evening, friends. This time, going beyond the series of constitution, we thought that why not understand the dynamics of relationship in respect of family and how that law has traversed. Those who have been connected with Beyond Law CLC would have seen that Mr. M. Arvind Subramaniam, the senior advocate from Madras High Court, has done few sessions with us, and they can be watched if you have missed it. The dynamics of relationship, we have all seen that how it has evolved, and the law, keeping in view the tunes and the trends of the society, also keeps changing. So, primarily, we will be dividing this session in two parts. The first session, today's session, would primarily cater or reflect on the dynamism of law on the civil side, different, a bird's eye view of all these perspectives. I will not take much time, and I'm obliged that Adi Lakshmi had introduced Mr. Arvind for all these wonderful sessions. Over to you, Mr. Arvind.
Good evening, friends. Good evening to all of you. When Mr. Vikas told me that I need to do a session with all of you on the dynamics of relationships in family and the criminal and the civil side, I readily agreed because I've been doing quite a bit of cases on these issues. Now, to start with, I can recoin the entire topic as a sweet and sour because everything starts very sweet in a relationship and sometimes it ends on a very sour note, and that's where we head for the courts to adjudicate on issues to be settled by law. So this is how I'm going to recoin the topic as sweet and sour. Thank you, Vikas ji. Now let me. I'm going to also present a slideshow so that it will be easier for you to understand and just not listening to whatever I say, but when you see those things, I think you can even take notes on that so that it will be easier for you to follow and understand. Is it okay, Vikas ji? Hello, hello, yes. Hello, hello.
Yes, yes, perfect,
Yeah,
perfect.
am I out? Yeah. Now I'll present
Yeah,
the first slide on the introduction to relationship. Relationship is a connection between two people. Let me present the first slide. Uh, a relationship is any connection between two people, and I'm sure the viewers can go through these slides to find out the intricacies of relationship and what is basically a relationship and why do we need a relationship. We need a personal relationship. It could be on the personal or the professional front. The personal relationships are include close intimate connections like the family, and the professional relationships are those whom we have in our profession, our colleagues, our bosses, our mentors, and if you are a lawyer, you are the judges whom you are going to appear before. So these are the broadly the two types of relationships which we are going to see, and how the law governs us both on the civil side and on the criminal side. Now let us take the personal relationships first. Now, personal relationships, as you can see on the screen, are first is our family, who are also our relatives, and we are also connected through some form of kinship, whether it is through blood or through marriage or adoption. So all these relationships are governed by laws. You have the Hindu Marriages Act, the Hindu Succession Act, and the Hindu Adoption and Guardian and Wards Act, and the Hindu Adoption Act. So these are broadly the laws which are presently governing the relationships on these aspects. Then comes the family, includes the siblings and the parents who you may see every day growing up, and you have the class 1 heirs, the class 2 heirs, and the class 3 heirs. So this is broadly the kingship which is related through blood, and these are the laws which I am going to take you through. Further, then we also have the legal bonds, which also include parents, siblings, grandparents, all those who are connected to a person through these bonds. Then we have the various types of families. We have the nuclear family, the binuclear family, the step family, the single parent family. Then you have the cohabitating family, and you have the same sex or the gay or lesbian family. And all these I've given the definition of what they constitute. So please go through these slides because it makes the presentation very much easier for all of you. I hope you are following it. Vikasji, I hope you are following it. The next one. Then you have the friends who are also there, for whom you interact, and there is a bond between you. And in a friendship, you have the question of trust coming between the two relationships, and you are governed by the 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 IPC also, where you have section 415 and the breach of trust, criminal breach of trust 406, which is also one of the important things which I'll be covering during the course of the second session, where I'm going to deal with the criminal law. And the next most important is that in a friendship it is voluntary, and sometimes it also uh, brings into a fiduciary relationship where you're going to trust your friend on so many important and personal things which you may not be able to share with your parents or anybody. Then you have acquaintances, the people you may encounter regularly in your business or in your profession, but they are not your friends or relations. For example, they may be a neighbor who lives or a colleague in your office and who may be working with you, but they may not be really your friends or colleagues. Then you have a romantic relationship where it is governed by the contract. You have a living relationship where, though you are not married, you are living together. You may have a contract, or you may not have a. You may have a written contract, or you may have an oral contract. In a written contract, you have a prenuptial contract. What is happens before a marriage, and next is what happens after marriage. Also, there are contracts which are now being entered into in various parts of India, and that governs the relationship between the two, including the tenure of your marriage. And if you want to continue with your marriage, you can extend the contract. This is very new, which I came across very recently in Bombay, where a couple had entered into a contract for a period of 5 years, subject to a mutual consent for them to extend the contract for another 5 years. But this is the first time I am seeing such a contract, and it was very interesting that they have covered a lot of issues, day-to-day issues between them, and that's very novel to me. Then you have the various romantic relationships, because I'm going into the dynamics because everything is governed by law. I am giving you an idea of what are the various types of relationships and what are the laws that are going to govern these relationships in a nutshell. Then you have a dating, then you have a committed relationship, then you have an ethical non-monogamy, and these are the various types of romantic relationships, and all are based on the question of trust and mutual understanding. And any violation of this, you can go before an IPC court, or a court for damages, or even a domestic violence act, where you can say that he has been violating the norms of a relationship. Or you can even go for maintenance. Even in all these relationships, you have a maintenance, also an agreement they enter into between parties to ensure that their relationships are bonded and strong. Now, coming to the professional relationships, you have the co-worker relationships, and you have a client relationships. In a co-worker relationship, it's based on circumstantial proximity due to a shared employer. Now, this is someone who is a professional acquaintance. Now, in these co-worker relationships, you have the Sexual Harassment Act, which is coming into effect in the famous case in 1997, which I'm going to share it on the screen also. And that was the basis on which they formed committees within an organization to find out whether somebody is sexually harassing somebody. It can be a man woman or a woman to man also, or a man to man if they have a relationship to that extent, or a woman to woman if they have a relationship to that extent. So, broadly speaking, these are the relationships. Then you have a client relationship, which is a fiduciary contract, where you have a contract between the client and the lawyer, or so that you ensure that the information that is comes into your possession is kept confidential, and the breach of confidentiality entitles you either to be reported in the bar council, or they can file a suit for damages or a consumer case, where nowadays the consumer courts don't entertain cases against advocates, and normally it is the bar council where you have to go and make a complaint if there is a breach of contract or a breach of trust. Then you have the mentor-mentee relationships at work, and it involves a seasoned professional guiding a worker with less experience. The mentor shares advice, knowledge, and resources to help the mentee improve their skills. This setup benefits both parties. When you in any organization, when you need to grow, you need a good mentor who understands you and helps you to grow. So, a question was asked in Microsoft whether you need a good company or a good boss. 99% answered good company, and there was one person who answered good boss, and that person became a leader, and he runs a company called Alibaba. His name is Jack Ma. I'm sure you have heard of that. He's one of the biggest. Is a giant in the field of software and industrial electronics, and this is one of the reasons why I say there is a mentor-mentee relationships. If you look for a good company, you can learn. If you look for a good boss, you can grow. So these are the two things which makes a difference, and that relationship of a mentor and mentee is extremely important for individual growth of any person. So this is one of the important reasons I said this relationship makes a lot of difference to the growth of a person, because he has a good mentor. Then coming to many times the workplace relationship policy, sometimes called fraternization policy, a set of guidelines and rules for relationships between romantic relationships between co-workers is implemented, because there is a code of conduct, and in many of the software companies they have this fraternization policy, so that the guidelines and rules are clearly set forth to ensure that the relationships are not violated, or the guidelines are not violated. It helps ensure that all interactions among colleagues remain professional, respectful, and consensual. It can also address sexual harassment, bullying, discrimination, and favoritism. Now I'm going to discuss this fraternization policy, and we have the famous Vishaka versus State of Rajasthan. A three-judge bench of the Supreme Court comprising Justice Verma, Manohar, Sujata Manohar, and B.N. Kripa held that sexual harassment of women at the workplaces infringes fundamental rights guaranteed under Articles 14, 15, Article 19, 1G, and 21. And the court in Visakha was the state of Rajasthan issued the Visakha Guidelines, which later became the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013. But much prior to that, Vishaka's case, we had a case in 1978. We had Rupen Bajaj versus KPS Gill, where an IAS officer was sexually harassed. was harassed, and the matter went to Supreme Court. It's a famous case that is in 1978, Rupan Bajaj versus KPS Gill. You can make a note of that. That was the forerunner to the Visaka's case. So if you read that judgment, you can understand why this enactment became necessary because of the frequent uh, harassment given to women in various fields. Rupan Bajaj was an IAS officer, and KPS Gill was the Director General of Police in Punjab. I'm sure you have all heard of that. And when that matter came before the Supreme Court, the KPS Gill was asked to give a compensation of 2 lakhs at that time, and that went to Rupan Bajaj used that money to give it to charity. So if you read that judgment, you will see that that was a forerunner to the present case. Then, following the guidelines laid down by the Supreme Court in Vishaka was the state of Rajasthan, the employers or individuals in equivalent positions must prevent incidents of sexual harassment from occurring. If such incidents do happen, organizations are required to have a proper mechanisms in place to provide both legal and conciliatory remedies. This is very important. That is what the fraternization policy of each company. It's like your corporate compliance. This has to be done by every company, and they have inspections to ensure that these uh, committees are in place and they are well governed. Now, coming to the definition of sexual harassment, it is an unwelcome sexual behavior, whether direct or indirect, such as physical contact and advances, requests or demands for sexual favors, sexually colored remarks, displaying pornography, and any other unwelcome conduct, be it physical, verbal, or non-verbal. So these are the various categories of sexual harassment, and the preventive measures which the employers must take to combat sexual harassment. These measures include issuing clear prohibitions against sexual harassment through notifications or circulars, then enforcing penalties for sexual offenders, then ensuring appropriate workplace conditions regarding hygiene, health, and leisure. Then handling misconduct. The employer is bound to take legal action by reporting the incident to the appropriate authorities if the misconduct constitutes an offence under IPC, that is 1860, which I will be covering in the second session. Then, of course, you have the disciplinary action. The employer must take suitable disciplinary action against the perpetrators in case of violation, which normally happens. And to conclude on this particular topic, that is the Visaka's case. The Visaka case marked a significant step towards securing a dignified and a safe working environment for women, offering legal clarity and practical solutions to prevent sexual harassment. The guidelines served as a de facto law until the Sexual Harassment of Women at Workplace, the Prevention, Prohibition and Reversal Act was enacted. The ruling reinforced the importance of a safe workplace for women and contributed to a broader fight for gender equality in India. This is not only applies to women, but this also applies to men who have also been harassed by women bosses. And if you read the book Disclosure by Michael Christian, you will know how a woman boss can harass a man who is also competing for a post with her in the organization. That's a very interesting book. It's called The Disclosure, and if you have a chance to read, please read that. It's written by Michael Krishnan, who is a very famous author, who has written several books which have been adapted into films, including the Jurassic Park. So, if you have a chance to read that book, please read that book. Then you have the Rupandial Bajaj versus Kanwar, KPS Gill and another. This is the case I was talking, which is a forerunner to the case of Visaka. The case of Rupandial Bajaj and another versus Kanwar so and so is one of the high profile and less and criticized cases in Indian. This involves an IAS officer who filed a complaint under 53, 41, 42, 52, 54, and 509 of the IPC. And then I'm sure you will, the slide gives you the description of the case. It happened in 1988, and the final decision came after nearly 17 years in 2005. So these are the cases which probably give a highlight about the um, sexual harassment of women in workplaces. So this is the broad background of the case, which you can see on the screen. Then the next relationship will be between the bar and the bench. The bar bench relationships refer to the dynamic interaction and cooperation between lawyers and judges. I am covering all these subjects under the relationship, the professional relationship. Uh, these are the subheadings which come under the broad heading professional relationships. The bar bench relations refer to the dynamic interaction and cooperation between lawyers and judges within the legal system, and this relationship is fundamental to the administration of justice. Lawyers represent their clients' interests in court, while judges make impartial decisions based on the law. Maintaining a respectful and a collaborative partnership between the bar and the bench is crucial for effective functioning of the legal system. So, these are the basic fundamental rules which govern the bar and the bench. Now, I would like to quote some incidents which took place between the bar and the bench, which probably will really help you to understand how the relationship was in those days. I'm sure it must be there. I don't see much of it today in these high courts. What happened was in one of the cases in 1945, there was a case of copyright in which it was heard by Justice APS Iyer, was a barrister of law and who headed the bench in the Madras High Court in the late 40s. So, a coffee supplier, a chicory supplier, was filed a suit against a coffee manufacturer, saying that 50% of the sales should come to him because it was because of the chicory added to the coffee that the coffee sold in such high volumes. The coffee manufacturer replied saying that but for the coffee, the adding of chicory will not make any difference to the coffee. Justice APS Iyer, who heard the case, mentioned that in the case of adultery and adulteration, you cannot argue that the substitute is better than the original, and henceforth dismissed the case of the chicory supplier, saying that you cannot say that the substitute is better than the original. So these are some of the incidents which uh, come to fore when you are talking about the relationship between the bar and the bench. Then you have the bar bench relations in professional ethics and overview. In a demo, I'm sure you'll be able to read the slides, which gives you a lot of information. But there is one case which see there is one case in which it's PD Gupta versus Union of India, where the advocate was trying to abuse the judge, and that became a very famous case. And it is one of the reasons why I have included that in this topic. There is any attempt by an advocate to discredit the court undermines the very foundations of justice and tarnishes the entire justice system. Advocates are expected to show consistent respect for the court, regardless of the court status. They must refrain from displaying personal bias against judges, as they are entrusted with the responsibility of upholding the judiciary's professionalism and respect. Conversely, it is a duty of the judiciary not only to be respectful towards members of the bar, but also to uphold the high standards of legal profession. And contempt of court can be imposed on lawyers or judges for disrespectful or improper behavior. Contempt of court can be categorized as civil or criminal, encompassing actions against, such as using derogatory language against a judge, questioning the authority, or making unbounded accusations, and which results in contempt proceedings. That is P.D. Gupta versus V. Ramamurthy and others. The case of P.D. Gupta versus Ramamurthy and another, that was in 1997 Supreme Court, was adjudicated by the Supreme Court of India on July 8, 1997, serves as a pivotal precedent in delineating the ethics boundaries that legal professions must adhere. This case revolves around allegations of professional misconduct against P.D. Gupta, an advocate in Delhi, who was accused of purchasing property from his client amidst ongoing litigation over the very property in question. The crux of the dispute lies in Gupta's acquisition of property from Vidyavati, his client, while representing her in multiple legal proceedings concerning the inheritance of assets left by the deceased Sri Kishan Das. The case not only scrutinizes Gupta's professional conduct but also underscores the responsibilities of legal practitioners in maintaining the integrity of the judicial process. The Supreme Court upheld the decision of the Bar Council of India, which found Advocate P.D. Gupta guilty of professional misconduct. The disciplinary committee of the Bar Council determined that Gupta has acted unethically by purchasing the property from his client Vidyavati, who was embroiled in litigation over the ownership of the said property. The court emphasized that Gupta's conduct undermined the purity of the legal possession, and the court found that his actions created a conflict of interest and cast a doubt on his impartiality, justifying the disciplinary measures imposed. So, this is one of the cases where the relationship between the bar and the bench soured, which led to the disciplinary proceedings initiated against P.D. Gupta, who followed unethical practices for his own personal benefit. Now, the next we are coming to fiduciary relationship, and it's very clear that fiduciary relationships are created in many legal assignments such as contracts, wills, trusts, elections, corporate settings. The main purpose of fiduciary relationships is to establish an honest and trusted relationship between two parties where one party can rely and be confident that the other person is working for their interest and are not using their power for their interest or the interest of a third party. Uh, then you come to the nature of fiduciary relationships, which covers a variety of relations having common features, and then it says what are the various relationships you have. Though there is no hard and fast rule to determine the existence of a fiduciary relationship, but it could be said that whether one has reposed confidence in the other and whether confidential relationship exists is a material test to determine the existence of a fiduciary relationship. Then you have the Supreme Court in Jaya Singh versus Krishna on the question of fiduciary relationship, that wherever a person clothed with fiduciary character obtains some personal advantage by availing himself of his position, such a person remains as fiduciary for all the profits which are to be held for the benefit of a person at whose expenses and derogation of whose rights the profit has been made or advantage derived. Then the principles. We have the principles of fiduciary relationship. I'm sure you can just go through all this, and it's very important that a man in a fiduciary relationship should be very careful of the trust and confidence reposed on him by the other person. Then the conclusion. Fiduciary relationship generally arises out of a dual relationship where one person reposes confidence in another, where a person sets on an act of another stands in a fiduciary relationship. Then you have there's a confidential obligation to act in the interest of another person. Fiduciary, therefore, is a person who is bound to act in good faith and with due regard to the interest of one reposing the confidence. Fiduciary relationships covers a variety of relationships. Some common features, whether the relation between the two persons is fiduciary or not, depend on the facts and circumstances of each case. So this is the conclusion. And now we come to the law governing relationships. Then you have a man and a woman, and you have the Special Marriages Act. In one of those cases, His Lordship Justice Chandrachud uh, clearly mentions that even in the Special Marriages Act, you have terms such as man and woman, and not using the person, instead, not using the term person, instead may unsettle existing statutes. And senior advocate Singhi, appearing for one of the petitioners, said same-sex marriage was a narrow term, and if the court were to grant marriage equality to gay couples, it would be for consenting adults across bodily gender and sex spectrum. Then this STSC reply, so Solicitor General replied, biological man means a biological man. It is not a notion. And CJI, Justice Chandrachud said it is a notion. There is no absolute concept of a man or absolute concept of woman at all. The biological definition is not what your genitals are. It is far more complex. That is the point. So this is how the law relating to marriages was discussed in the Supreme Court, and we have the personal laws. Uh, then you have the personal laws. We have the laws governing the relationships between a man and a woman. The heterosexual relationships are governed by various provisions in personal laws, with the Hindu Marriages Act governing marriages between two Hindus. Although the Act does not expressly prohibit same sex marriages, it assumes relationships between a man and woman only. So we have Section 5, which mentions the time of marriage, the bridegroom must be 21 years of age and the bride 18 years. Hindus includes Buddhists, so on and so on. One of the essential rituals being the Saptapadi, which is, unless Saptapadi is done, it doesn't give the sanctity of a marriage to a man and a woman. Then we come to the Muslim Personal Law, the Shariat Application Act, which governs the application of Islamic Shariat law to Muslims in India. It was enacted to ensure that the Muslims are governed by their personal laws. Governed by Islamic principles include like nikah, talak, kula, and mubah. So they also typical views homosexuality as haram is forbidden even under the Muslim law. Same-sex acts could be subject to punishments. However, interpretations of Sharia are not uniform, and there is a growing movement among progressive Muslim scholars and communities advocating for a more inclusive understanding. Organizations like Muslim Alliance for Sexual and Gender Diversity and Muslims for Progressive Values are working towards reconciling Islamic teachings with LGBTQ plus rights, challenging traditional reading of religious texts. So there is a revolution happening in even in the Muslim law. Then you have the Christian Marriage Act, which regulates marriage between persons if at least one of the parties is a Christian, provided it is solemnized according to the rules, rites, ceremonies, and customs of the church. Then you have the Special Marriages Act, which establishes legal measures to protect those who marry across castes or religion. Section 4C talks about the requirements of male and female. Canon law defines marriage as a covenant between a man and a woman aimed at the procreation and education of children and the mutual good of spouses. This definition inherently excludes same-sex unions. It's very important. Then we are now coming to the modern era of homosexuality, that is the Nas and Supriya's case. I'm sure you must have read about it, and it was a very recent origin. That is Section 377 of the IPC criminalized same-sex relationships. Nas Foundation versus Government of NCT is a landmark Indian case decided by two-judge bench of the Delhi High Court, which held that treating consensual sexual between homosexual sex between the two adults is a crime in violation of the fundamental rights protected by India's constitution. The verdict resulted in the decriminalization of homosexual acts involving consenting adults throughout India. This was later overturned by the Supreme Court in Suresh Kumar Kaushal versus Nas Foundation, in which A two-judge bench reinstated Section 377. However, that was overturned by a five-judge bench in Navtej Singh Zohar versus Union of India in 2018, decriminalizing homosexuality once again. So these are the various laws which we are going to uh, see. The progress of law, as I would say, progress of law from the 1955 Hindu Marriages Act to the latest Navtej Singh Zohar's marks a transformation in the dynamics of relationships between a man and a man and a man, and a woman and a woman. So these are broadly the various progress made by law, ensuring that how the dynamics change in relationships between a man and a woman, and a man and a man, a woman and a woman, over a period of time. And it is the progress of law which marches or guides the relationship between individuals. So now, now coming to the NAS case, because the NAS Foundation stressed that courts in other jurisdictions have struck down comparable provisions relating to sexual orientation on the grounds that they violated the rights of privacy, dignity, and equality. The MHA, on one hand, argued for the retention of Section 77, and first that it is provided for the prosecution of individuals for the sexual abuse of children. So then certain other factors were also brought into these arguments in this NAS Foundation case. But in contrast, the Ministry of Health and Family Welfare, in conjunction with National AIDS Control Organization, presented evidence in support of NAS Foundation submission that the continued existence of 377 is counterproductive to the efforts of HIV/AIDS prevention and treatment. They argued for removal of Section 377, stating that it makes a large number of people in high risk categories in relation to HIV/AIDS reluctant to come forward for treatment due to fear of law enforcement agencies. And I'm sure in the latest uh, IPC, which is now the BNSS Act, 377 has been removed. You don't have 377 in the new Act. So this has been the march of law due to the progress of society and the dynamics of relationships. Then the Delhi High Court's decision was a landmark ruling for LGBTQ plus rights in India, decriminalizing. So I think now we have seen that. Now we come to Supriya Chakrabarti versus another. This is another important case. Writ petitions were filed by two same-sex couples. They challenged the validity of Section 4C of the Special Marriages Act on the ground that the provision discriminates against same-sex couples by denying them the benefits. On 13th March 23, a three-judge bench led by Justice Chandrachud referred the case to a five-judge bench, the Constitution bench. The petitioners presented an argument invoking Article 32, which empowers Supreme Court to safeguard the fundamental rights, and Article 14, which ensures right to equality. In a 3-2 majority, the Supreme Court reached a significant verdict regarding the legal recognition of same-sex marriage. The majority, comprising of three judges, declined to grant legal recognition to the same-sex marriages. They asserted that the right to marry is not inherently a fundamental right, emphasizing that it falls under the purview of the Parliament to make determination regarding the legalization of same-sex marriage. Furthermore, the majority judges maintained that 4C of the Special Marriages Act, a key piece of legislation in question, does not infringe upon the fundamental rights of the same-sex couples. Their rationale centered around the belief that the same-sex couples possesses alternate legal avenues such as living relationships and civil partnerships, which adequately address their needs. And on a review against this order, Justice Gawai dismissed the review petition on the ground that there is no provision under any of the law for same-sex marriage. So this is the latest uh, on the same-sex marriage. So the dissenting judges were Justice Chandrachud and Hima Kuli held contrary point of view, and the majority of the judges held that same-sex marriage cannot be entertained. This is the review of the Chandrachud's judgment. On Thursday, a bench headed by Justice Gawai and comprising Justice Suryakant, B.V. Ragaratana, P.S. Narasimha, and Dipankar Datta unanimously ruled that the review petitions were devoid of merit and rejected the pleas for open court hearing on contentious social issue which now stands more or less settled. Same-sex marriage will remain illegal unless a law is enacted to make it legal. So this is the present position as of date. The bench also held that the majority of opinion of Justices Butt and Kohli, with which Justice Narasimha had concurred in 23 judgment, required no interference, as the review petitions failed to point out any error in the judgment. So this was the latest judgment in 23 October 23. Then we have the other option, that's the same-sex marriage. LGBTQs still have option to file curative plea, in which we have carefully gone through the judgments delivered by Bhatt as well as the concurring opinion expressed by one of us constituting majority view. We do not find any error apparent, and however, LGBTQ community members still have an option in the form of a curative petition, which, like review petitions, and if filed, would be taken up by a five-judge bench in chambers without assistance of lawyers. So this is where it stands as far as this issue is concerned. This is only the prelude to the review petition. Then we have the concept of live-in relationships as a practice avoided by Indian society for a long time. And then you can go through the slides to have a better understanding of these relationships.
Mr. Arvind, you have not changed the slides.
Pardon me? Pardon
You
me?
have not changed the slides. You have not changed the slides, I said.
I'm seeing the slides. Yeah. Why?
No, you have not changed the slides. Just check it
Who?
out.
Oh, the viewers are not able to see the slides.
No, you are not changing the slides with time.
Huh? I think maybe a network issue, Vikasji, because I'll just a minute. Yeah. Is it okay now?
No. On the right side, on the main screen, it's
Right
not
side.
coming. On the main screen, it's not coming. So whatever screen you are touching, you will have to touch. It will come on the main screen.
Okay. Is it coming now?
No, it's still click to add title.
Sorry. Yeah. Now is it okay?
No. You can do away with the slides. We'll post it on the website.
Okay. So, so I'll just it's like any other oral lecture I'm giving.
Yeah. You can do away with the slides.
Yeah. So now we have the live-in relationships, which is legally considered void ab initio. Video. Am I audible now? Am I audible?
Yeah. Audibility was never an issue.
Yeah. Now, in a live-in relationships, it's legally considered in a judgment of the Supreme Court in 1978, which is one of the earliest decisions, where we had Indra Sharma versus VKV Sharma. The brief facts of the case are Indra Sharma was an unmarried woman who quit her job and started a live-in relationship with a married man called VKV Sharma. And that relationship continued for about 18 years, despite knowing the fact that Sharma was was a married man and he had children. And he established a company in the name of Indra Sharma, and they were making money from it. Then later he moved the business to his home and continued if there were assistance of his son, and denying the opportunity to Indra Sharma to work and earn money. It was claimed in the petition of Indra Sharma that BKV Sharma left the company of the appellant without supporting her financially because his family consistently opposed their living relationship and ultimately forced him to do so. The failure to support a woman who is involved in a domestic relationship is considered a domestic violence under the Protection of Domestic Violence Act 2005. And she filed a petition before the Domestic Violence Court, and she was awarded maintenance by the Domestic Violence Court, which was upheld by the Supreme Court. Now, the court makes a reference to a few potential relationships that might qualify for DV's Act protection in order to further support of its observation. The domestic relationships involving same-sex partners are not covered by Section 2F because they fall outside the purview of the Act. The court also stated that there is a need to broaden the scope of Section 2F of the Domestic Violence Act, which defines the phrase domestic relationship. However, domestic relationship involving an unmarried man and an unmarried woman would be the guidelines laid down by the Honorable Supreme Court in the case are as follows. Duration of the relationship's initial phase. According to 2F of the DV Act, the phrase at any point of time refers to a fair amount of time to sustain and continue a connection which may differ from case to case. The phrase shared household is defined under Section 2S of the DV Act. Resource pooling and financial arrangements. In order to maintain long-term relationship, they need to assist each other financially. These are the parameters under which
Mr. Arvind, you have closed your video.
video.
Yeah.
No, I think it's switched on there because
No, it's closed. Your video is closed. Just check it out.
yeah. Where it's on? Switch on the video. Video.
Your video. Yeah, no, it's fine.
Is it okay?
Yeah.
Slide on the video. Now, am I visible? Because am I visible?
Yes, it's fine.
Yeah. Then coming back to the Domestic Violence Act, we have the guidelines was laid down by the Honorable Supreme Court are as follows, which I mentioned: duration of the relationship's initial phase. Then what 2F says about the DV Act, which states that at any point of time, referring to a fair amount of time to sustain and continue connection, which may differ from case to case. Then the phrase shared household is defined under Section 2S of the DV Act. Resource pooling and financial arrangements. In order to maintain a long-term relationship, they need to assist each other financially. Domestic arrangements, putting the burden of running the household is on the women. Sexual relationship, sexual interactions that are not simply for fun but for emotional support and childbearing. Then they define what is children, public socialization, parties' intention and behavior are some of the criteria which support the concept of a domestic relationship. So this is very important when you are filing a case under the Domestic Violence Act. Then I will also, because I did a topic in Goa, I am just wanting to highlight what the Goan laws also say, because they are very different from the Hindus Act, the Hindu Marriages Act, which doesn't apply in Goa. Normally in Goa, you have the Portuguese code, which governs relationships in matters such as marriage, divorce, inheritance, and succession for all citizens of the country. Article 44 of the Constitution, which is one of the directive principles of state policy, advocates a uniform civil code. So in Goa, they have a uniform civil code which governs the laws relating to marriage, divorce, inheritance, and succession. However, governments since independence have allowed respective religion-based civil codes to respect the diversity of India. The Goan Civil Code is derived from the Portuguese Civil Code of 1867, which was applicable during the Portuguese rule in the state. The 1867 Portuguese enacted the Portuguese Civil Code, and in 1869 it was extended to the Portugal's overseas provinces that includes Goa. The law provides for compulsory registration of marriages before a civil authority, ensuring that the wife is an equal inheritor and is entitled to half of the common assets, including those inherited by her husband in the case of a divorce. In the absence of a prenuptial agreement stating otherwise, and that the parents must compulsorily share at least half of the property with their children, including daughters. So, this is one of the forerunners to our Hindu Succession Act of 1955, where, as per the decision in Neha's case or in Sharma's case, Vineet Sharma's case, the daughters inherit the properties of their fathers since birth. They become a co-partner since birth. So this had its roots in the Portuguese Civil Code, where it says that half of the property belong to their daughters, if there are daughters. The Portuguese Civil Code in Goa continued in India by virtue of Section 51 of the Goa, Daman and Dayu Administration Act in 1962, through which the new Indian administration ruled that all laws in force immediately before the appointed day in Goa, Daman and Dayu or any part thereof shall continue to be in force therein until amended or repeatedly repealed by a competent legislature or other competent authority. Because of this, the Portuguese Civil Code continues to be in force in Goa, despite being replaced in Portugal, the country of its origin, with a more modern Portuguese Civil Code 1966. These are all very important inputs when you're relating to the laws, the diversity of laws in India, because the Goan laws are entirely different from the laws prevailing in other parts of the country. That's why I thought I will highlight these laws, which which marks a difference to the other laws prevailing in the country. When it comes to marriages, the law uniformly mandates that there will be a two-stage process commonly referred to as the first and second signature. The first being the statement of intention and calling for objections, and the second signature being the formal marriage. Then there is a unique concept of matrimony property rights, which is not found in the personal laws of the rest of India. See, this is a very unique code where you have to understand that in Goa, Daman and Dayu, they have an entirely different set of laws, which are very different from the other laws in India. In Goa, if nothing is spelled out at the time of marriage, the default system is the regime of the communication of the assets, communion of assets, which means that upon marriage, couples will hold whatever assets they have, each or jointly acquired or inherited before or after the marriage, as co-owners of the property. The Uniform Civil Code in Goa is a progressive law that allows equal division of income and property between husband and wife, and also between children, regardless of the gender. Then every birth, marriage, and death have to be compulsorily registered. For divorce, there are several provisions. The Muslims who have their marriages registered in Goa cannot practice polygamy or divorce through the triple talaq. This is one distinction which is very different from other parts of India. During the course of a marriage, all the property and wealth owned or acquired by each spouse is commonly held by a couple. Each spouse, in the case of divorce, is entitled to half the property. In the case of death, the ownership of the property is halved for the surviving member. The parents cannot disinherit their children entirely. At least half of the entire property has to be passed on to the children. This inherited property must be shared equally amongst the children. However, in the code has certain drawbacks and is not strictly a uniform code. For example, Hindu men have the right to bigamy, which you will be surprised to know that in Goa, Hindu men have the right to bigamy under specific circumstances mentioned in the codes of usages and customs of Gentile Hindus of Goa. If a wife fails to deliver a child by the age of 25, or if she fails to deliver a male child by the age of 30. For other communities, the law prohibits polygamy. Goa is the only state in India that has a uniform civil code regardless of religion, gender, caste, and Goa has a common family law. Thus, Goa is the only Indian state that has a uniform civil code. The Uniform Civil Code will provide women with the right to equality and justice in the courts of law, irrespective of their religion in matters pertaining to marriage, divorce, maintenance, custody of children, inheritance rights, adoption. The Supreme Court for the first time directed the Parliament to frame a UCC in the year 1985 in the case of Muhammad Ahmad Khan versus Shah Banu Begum, popularly known as the Shah Banu's case. In this case, Shah Banu claimed for maintenance from her husband under Section 125 CRPC after she was given a triple talaq by him. However, the government overturned Shah Banu's case decision by a Muslim Women Right to Protection on Divorce Act 1986, which curtailed the rights of Muslim women for maintenance under Section 140, 125 CRPC. The Supreme Court in Shayara Banu's case, 2017, has declared the practice of triple talaq as unconstitutional. The most important thing under the Uniform Civil Code will provide a women with the rights to equality and justice in the courts of law, irrespective of their religions and matters pertaining to marriage, divorce, maintenance, custody of children, and inheritance rights. The Supreme Court the first time directed the Parliament to frame a UCC in the year 85 in Shah Banu's case, and then they brought the new act. The Catholics enjoy certain privileges such as exemption from marriage registration and the ability of Catholic priests to dissolve marriages. Catholics can solemnize their marriages in church after obtaining a no objection certificate from the civil registrar. For others, only a civil registration of marriage is accepted as proof of marriage. If the marriage is not consummated, a church tribunal may declare it null and void. However, non Christians must obtain a divorce through the courts. They cannot do so on the grounds that the marriage has not been consummated. The Goan civil procedure enables a particular type of polygamy for Hindus but does not extend the Sharia Act to Muslims living in Goa who are instead subject to both Portuguese and Shastric Hindu law. The law also doesn't recognize bigamy or polygamy, including for Muslims, but grants an exception to a Hindu man to marry once again if his wife doesn't conceive a child by the age of 21 or a male child by the age of 30. A divorce granted by the ecclesial church authorities is treated as a valid divorce for civil purposes, while for non Catholics they have to get a divorce from a civil court. Because can we stop here or shall we continue?
No, we can do it in the part 2.
Pardon me?
We can do it part 2 later on.
Yeah, because there are a lot of other things I have to cover.
Yeah.
Because these are all new subjects which probably not many would have covered, especially the Goan law, which is very unique to the other Hindu acts which are prevalent in other parts of the country. So this is why I thought I will take it a privilege to be here to talk more about the diversities of law in the various states in India itself.
That's true.
So
if you want to summarize the entire bullet points in 5-10 minutes, you can do that.
No, I think I'll continue it in part 2.
Okay.
Then I'll make a total summary. I'll summarize the entire thing.
Okay.
Because there are quite a few cases which I have to cover, and that probably would be more interesting also under the criminal law.
Yeah.
And I can cover the entire dynamics of relationships in part 2 whenever you choose to have.
We will do that.
Definitely will do that.
Thank you, Mr. Arvind.
Thank you so much, Vikasji, for the invitation to present this unique topic, because not many would have covered the dynamics of relationships, because it's varied, and considering the vast nature of the population and the caste and the creed.
Thank you.